That worked. We thank you. Can how's the sound? Can you hear me okay? It's too loud, not enough? What? A little closer?
Yeah, thanks.
How about that? Is that better? Okay, I have to kind of lean in for that. Maybe if I move it. How about now? Can you hear me in the back? Yeah. Okay. So let me put on my timer, see if I can get through this. So I'm here today because of an interesting request in the Ninth Circuit Library. And wait, is oh, the slide thing isn't working. Where's the, oh, maybe this, let's see. It's not moving. Let's see. Oh, I can just click here. Okay. All right, I'm going to click on the trackpad instead of the down key. And so, start my timer back up again. So, I want to thank Julie for inviting me here and Hefuyo, who was absolutely great about supporting the speakers and travel coming here. It's just, he was totally on top of every single detail. He didn't make one mistake. And every time I contacted him, he was right in the pocket. And I don't think I've ever seen that before. So really good job. And to you, yes, to you for having me today and letting me learn with you because I feel like I'm here as much to learn as I am to you know, actually, I'm not even coming as an expert. And to NoCal for the sunshine because I came from Portland and it's gray and rainy there, and it's going to be gray and rainy when I go back on Sunday. So, I'm going to be talking a bit about the Portland Branch Library in the Ninth Circuit, just as an overview, and the request that I am talking about. And I'm going to try to leave 10 minutes for discussion. Okay. Now, but I want you to keep in mind, I'm kind of intimidated by what I'm hearing here today because I see a lot of people who have done a lot of legislative history research. And I want you to keep in mind, I did work at the Legislative Research Library in Louisiana years and years ago, but I wasn't doing that. And since I've been at the Ninth Circuit, I've been basically a branch manager alone of a two library place several times alone, not anymore. And I am not a legislative history expert, but I did get a request that I want to tell you about and kind of walk you through what I experienced when I did it. I'm sure that many of you have more experience than I do. And one thing that I think Julie suggested that I bring this is that when I brought it to the Ninth Circuit Librarians conference between all of our librarians in Seattle, I just gave a very high level flyover of this issue. And it was like 4 slides. And all of the librarians were like just at the edge of their seats and they found it really interesting and they had not run into this situation. So what I want to see today is that true for you all, or am I like just going in the wrong direction? Um, if I think it's best if you have questions or thoughts, please jot them down and let's discuss them at the end. And the Zoom attendees, you can go ahead and enter your questions and comments in the chat, but let's Steph handle them at the end if that's okay. Okay, first about the Portland branch judges in the Ninth Circuit. Some of you know this. Julie for certain knows this, and Christina, who's with us, hey Christina, knows this. But for the rest of you, the Portland branch is one of 19 branches across the Ninth Circuit. There are only 2 branches with 2 courthouses and 2 libraries with the same staff, and that is Portland and Seattle. All the others, each branch has their own staff. And the Ninth Circuit Library acts as a large team, but each branch owns its own staff and requests. We can and do ask for backup help, and we use Microsoft Teams to do it. We overnight ILLs and scan documents to each other all the time, and more we're doing that across the whole entire judiciary. And the team and workplace are awesome. We're going to be sad to lose Julie. It's very soon. One of the courthouses in the Portland branch is the Pioneer Courthouse. As you can see, it's a historic courthouse in the center of Portland. Very fancy. We get very fancy visitors there, and there's a lot I could be telling you about that, but I don't have time, and I'm just going to move on. About 5 blocks away is the district court in our branch. It's the Hatfield Courthouse. And in 2019, we had a complete downsize. And we, instead of putting a lot of books in the place, we made it more for people and gathering. And I believe we have one of the few or only rooms like this in the federal judiciary, and we're really, really grateful. So it's an interesting branch. That's what I'm trying to get across to you. Portland has two librarians. Some of you may know Lee Van Duzer, who used to be the San Jose librarian at the Ninth Circuit, and then he moved back up to Oregon to be near family at another library for like 10 years, and now he's with us. And I'm very, very grateful to have Lee. He's just a really a stellar person and a stellar librarian too. Um, about our judges. And I'm thinking this room may know this slide. I didn't know exactly who the audience was going to be, but appellate judges live and work in every state. I didn't used to know that. We have only 4 appellate courthouses in the Ninth Circuit: San Francisco, Pasadena, Seattle, and Portland. But oral argument is sometimes held at district courts, and it's sometimes held even at law schools. But primarily oral argument is held at those 4 courthouses. Judges ride the circuit, not on a horse, but in an airplane seat usually, and sometimes in a car now to get where they're going. And they serve in panels of 3 in all these different places where they're hearing oral argument. Of course, a lot of the work is not done at in-person oral argument anymore. The Portland branch has 29 judges, 4 appeals, 21 district, and 4 bankruptcy. And we also have 6 locations in Oregon that we manage. So with the 2 libraries. So we've got our hands pretty full. Chamber staff, our branch onboards 30 newish law clerks and 60 externs per year. Law clerk in the court is a lawyer, and some with several years of practice under their belt. And an extern, I think, is what you all mostly call a law clerk. It's a student. And our branch onboards 30-ish new law clerks and 60-ish externs per year. And I will say this, you probably know, appellate clerks are sharp. They really are. Their research skills are really good, and that's relevant to this request I'm going to be telling you about. And if you have questions about the Ninth Circuit, let's just talk today later, maybe at the appetizers or call or email. Okay? So the request. That had a surprise for me anyway, and I wonder if it's going to be a surprise for you. Let me tee this up. So this was last summer, and I got by email an urgent rush request from an appellate clerk. It was Sunday night at 9 p.m. And no, I was not on my computer at Sunday night at 9 p.m. I got up in the morning, looked at my phone where I have my email, and I saw this at like 7 in the morning. And I was going to go to work that day, but I was like, oh my God, I recognize exactly what this is, and I need to get to my computer and get at the table right now and do this. I got a cup of coffee, went there, and you may have heard of the guy who brought this case. Um, It was an emergency appeal filed by the DOJ to stay a TRO coming out of California prohibiting the Guard deployment in Los Angeles. So it's the Newsom v. Trump case. They don't usually tell us what the case is, but I knew what it was from the question she was asking. Now, my coworker Lee, crackerjack researcher, happened to be on vacation. I'm like, oh God. And then what is the first thing I did? I looked up the judges who were on the panel with my judge, because you don't know who they're going to be. They could be anybody. And I called those 2 librarians and I said, okay, what about this? And they're like, we didn't get this request. So then I was like, let me go to our go-to legislative library history librarians who are busy, but they were busy with their own staff that day. You may remember that we have all kinds of different librarians, different branches that are doing different kinds of work. And some of them are, experienced in legislative history. We have one who was a Supreme Court librarian, and we try to get those people. Christina, who's on the call, is one of them, but I don't think you were available that day, Christina. I did end up asking a few others for help that afternoon, and it was a long night, day, next day. I'll just say that. Now, why was this case in Oregon? Well, one of our Oregon appellate judges was assigned to that 3-judge panel. And branches like ours with 2 courthouses can get it from both sides, district and appeals. You may have seen this guy too. First in the California appeal that I'm talking about, then we got it from the Oregon District Court case. Judge Immergut may ring a bell. Then the Oregon appeal, Judge Graber had a notable dissent in that case, which I recommend reading both of those opinions if you can. And then there was an Oregon rehearing en banc. This is the Oregon v. Trump litigation. But that was dropped because the DOJ dropped it after SCOTUS ruled on this issue about the National Guard. And I want to say that litigation is still ongoing everywhere about this, and a lot in Oregon. about the ICE protests. There was just one Wednesday at the district court. And what hasn't been in the news a lot lately are these cases where someone shows up at an immigration hearing, and these are executive branch hearings where they're not getting their bond hearing and they're being snatched by ICE. And so they're taking these cases to district court across the nation. And what's happening is that these people who have been planning this are very good at picking the laws that they want to challenge. And in this case, all of the district court litigation about that is novel law. So what you have is district court judges citing each other because there's nothing out there. It's very interesting. So back to this particular, are you all following me? Okay. Just want to be sure. All right. Getting back to this request that I got, it has to do with federalizing the National Guard. It was, as I said, the Trump v. Newsom. And the question was, and remember, this was like, I need it today, okay? When the text danger of a rebellion was added and to the current statute, she was able to say that she knew that the Dick Act of 1903, also known as the Militia Act of 1903, did not include the exact phrase danger of a rebellion. Instead, it said danger of invasion or of rebellion. So danger was separated from rebellion in 1903, and she wanted to know, when did this show up? I can't find it. So this is what the current statute is, and you probably may have seen it in the news. I saw this 12406 a lot of times in the regular news. They were talking about it. What it looks like now, it's not a paragraph, it's whenever we're talking about invasion, we're talking about rebellion number 2, or we're talking about executing the laws, number 3, okay? But if you look at the statutory notes, I think that's what they're called down there, it only goes back to 1994. So that means more digging is needed. And so here I am at my kitchen table, and I'm like, well, I think she did her work. I'm going to do the best thing I can think to do right now. I'm going to go into the Westlaw legislative history database, and I'm going to run this phrase in there. So that's what I did, and I got lucky. Now, I've been told by one of our librarians now that was not the smartest thing to do. That, but because what these legislative databases may be incomplete, it doesn't have everything, it doesn't go all the way back. But I was looking at this has got to be done today. So and it's an important case. That's what had me all freaked out. And it's just me, who's never done really one of these before. So I did go there, and I found the phrase in 1956 at 70 Stat 1126. Okay, that's the statutes at large citation where this legislative history was in the Westlaw legislative history database, mentioning the phrase danger of rebellion. Okay, you follow me? You with me? So I'm giving you a clue here, though. So then I went and got Hein online because I didn't have the books in front of me. I was still at my kitchen table. I got this snippet from that citation, and there's a clue here as to the problem that I encountered that day. And I want to let you take a look at that screenshot. Can you read it? No. No, not in the back? Okay. Well, can I? I don't know. I'm going to be showing this a little further. So I'll just say there's a line at the bottom. I'm going to be giving it away a little bit, but this act is printed as Volume 70A, U.S. Statutes at Large. Does that ring a bell for anyone? Oh, good. I don't feel so dumb. Okay, let's keep going. So anyway, this is what the GAO, maybe all of you know this, but this is what the GAO history that I found on the Westlaw Legislative Database looked like. It's just a collection of PDFs, and where your language shows up, danger of a rebellion, it's in yellow. So I went through all of those, and there was nothing that was not in the statute itself saying danger of rebellion. There was no commentary, no discussion, anything. So essentially, we found the history, but there was nothing in the history that would help my law work. Okay? So then I said, well, let me go back and look in Westlaw and just look at the notes and see if I can start tracing it back. And I said, oh, it only goes back to 1994. That's not going to help me. So then I reached out to one of my other librarians who was then available, and she does legislative history, and she decided she was going to walk back the statutes for me in the USC while I was looking around other places. By this time, I think it was the afternoon. When she walked back the code, she went to the 1958 code because we're talking about 1956. I shared with her, but also she found it. You can see in 1958, it doesn't have that paragraph anymore. Can you see that on the left? At least you can see it's 1, 2, 3, right? And, but the notes at the bottom of that, you probably can't see this. It says 70A stat 199. Now, this is the statute in the US code. It's not 70 stat 1126. So here my heart dropped into my, here, because I had already given the law clerk 70 stat 1126 and told her that's where the legislative history is, and there's none there. And I thought, I got this wrong. And this is probably the biggest case that I've ever worked on since I worked at the Ninth Circuit. And so I started looking around more. So 78 stat 199, you can see that's where the language is, but it was at 3500. That's the one all the way on the right. But it points to the one in the middle is 70A stat 1. I'm going to give you a bigger picture of that now. And there's another clue here, but I don't know if the text is big enough. Can you all see? So this is the one, remember when it said this is printed as 70A? That's what this is. Okay. Can you see anything at the top that might be a clue? There have been a couple of clues. It says public law 1028. That's a hint. No? Okay, I'm feeling a lot better, y'all. I was like, you missed it, but I'm doing good. Okay. So what do we know so far? We know that this language existed at least back to 1956, right? Because I found it in the legislative history, and it was in the statutes going back to a completely different statutory citation, but in 1956. Both of them were in 1956, but they're two different statutes. So I'm like, what does this mean? We know that somewhere between 1903 and 1956, the language was changed to danger of rebellion. We know that because we've got the Dick Act and we've got the 1956 thing. We haven't found anything in between. We know it was changed sometime, but we don't know when. That's what she wants to know and why. And we have these two statutes at large citations from 1956. What is going on? Why do we have two statutes at large citations? Has anybody ever seen this? You have. Okay, don't say anything. Was it this law? No. It had to be. There's another one.
It happens in California laws when they're really big laws.
Oh, okay.
Or if there are multiple laws.
Oh, yeah, they put them in an appendix.
Published somewhere else because it takes up too much space, is what I have found.
And it will have two different statutory citations?
Yeah.
Interesting.
No, it's not common.
Okay, so she said in California, you will see this sometimes in the statutes. Could everybody hear that? Okay. Now, 78 stat 1, that's the one, remember, that's the one that was published as the appendix to 70A. It was, now my colleague told me it's positive law and there's no legislative history for it. And I said, well, I found some legislative history for this, but it was at 70 stat 1126. And so we were all not knowing what was going on. And what I learned about Title 10 was that it was a big, big undertaking that happened in 1956. That was a painstaking recodification that took dozens of lawyers and researchers from the House Judiciary Committee and Pentagon, 10 years to complete. So it was a revision. And this was before the creation of the Office of Law Revision Council, which many of you may have heard of. And I'm going to tell you a bit more about that now. So this is what it looks like in the books, okay, of statutes at large. Those of you who are in the library all day may be well familiar with this. But the one on the left, you can see it's volume 70, and then next to it is volume 70A. So that's where these two citations are that I'm talking about. Now, the one on the right, you see something similar. It's just, I put it on the right, but really it's on the left on the shelf because this is volume 68, 1954, and it's the Internal Revenue Code. This one is done in 2 volumes, but there also is an a 68A. So I'm like, that's it. All positive law titles are published as a short appendix in the statutes at large. Don't make stupid assumptions like that. That's what I was thinking at the time, but it's not true. So how many of you have seen this site here? Most everybody or not? Oh, okay. I was thinking maybe more. This is the Office of Law Revision Counsel, where you can find the U.S. Code online. It's a House of Representatives law site, website, and they are House of Representatives staff. And their job is to take all these statutes and the statutes at large in a particular title and to make them into a code, what we call the U.S. Code. But their job is also to take all of these statutes and put them in a code that's so tight that they can present it to Congress and Congress can vote on it. And then it is a positive law, which has the same force as a statute. And maybe all of you knew that. I knew that, but I didn't know exactly how it was done. Okay. And what is positive law exactly? Just for maybe the few who don't know. It's basically law created by humans, is what I read on their webpage. But for our purposes, it's a title that has been enacted as a statute and has the same force of law as a statute. The statute is usually primary, the code is secondary, but when it's a positive law title, they're equal. Now, does this site, the OLRC, explain this dual citation problem that we're having, 70 and 70A? No, it doesn't. I called them up to say, what the heck is going on here? I don't understand it. And the attorney I spoke with said, I don't care about that. That's Office of Federal Register and Statutes at Large. But I want you to tell them about this section of the code right here, 1 USC 204, which I've put a link to here, because it has a list under it in the editor's notes of all the positive law titles currently in the U.S. Code. And that's I'm going to show you another trick, but that site has not only the titles, but it's got the parallel citations. They're all in a table. So it's a good thing to bookmark. Now, this is what the note looks like under that 1 USC 204. And you'll see Title 10 is there. There's that 70A Stat 1 on the end, but it doesn't have 70 Stat 1126 there at all. So again, you've got the legislative history in one place, you've got the text of the law in another place, but we're not getting any finding aids to bring the two together. Are y'all following me? Is this making sense? Okay. And then also note that there is only one A volume on this list. When you're looking at the statutory citations, statutes at large, there's only one, 70A Stat 1. So that blows my idea that, oh, they're all published as an appendix, all these positive law. No, that's the only A there is. You follow? Okay. So I'm not going to go through this. Suffice it to say, their tables are there, but they're confusing. And for this, they don't really bring any joy unless you unless you had clicked into that PDF. And here, remember, I'm in a rush. I'm going fast and I don't know what I'm doing. So if I had clicked into that PDF and looked at the front, and you all probably know, oh, that's the first thing you should be doing is clicking into the front page and looking and comparing them. Yes, that's what you should be doing. But these tables don't really lead you there, and they're not providing any cross references between the two. So you see it together sometimes. Now, I will say that much later, that day I did ProQuest Legislative Insight, legislative history, compiled legislative history searches. Is anybody not familiar with that? Okay, good. Everybody knows that. Well, what I didn't do was search in congressional publications, which instead of having the compiled legislative history, it's all the congressional documents over here. And if you search through a phrase, it doesn't only have to be in history, it can be in any document from Congress. And when I knew this was 1956 later, and I searched it, oh, look at this. This is the only place in our traditional tools that I ever found the two together. You can see here it's 70A Stat 1, and they're citing the same House bill. What is that called, HR? Is that a bill or what you call it? Well, I know, but it just means, but I mean, is it an enrolled bill or what is that? The 7049, do we know? Anyway, I'll keep going. Um, and then you've got 70 stat 1126. You've got the two there together, but it doesn't cross-reference each other. You're not finding any cross-referencing between the legislative history and the text of the act. Now, I'm freaking out this day because I think I got it wrong. I don't know what's going on. I don't have any time. And they had, this was for a, like I said, it was, an emergency appeal, and they had like the oral argument like 3 days later. And I watched the oral argument, and you can watch it if you want on the website. And they focused not on this at all. They focused on Section 3. Thank goodness. So it was kind of over for them. And, we're busy. I moved on, right? I didn't have time to go look into all this until Julie comes and said, hey, you want to talk about that? And I went back to what I did at the branch conference. I'm like, oh my God, that's only 4 slides and a very high level treatment of this. I don't really know. So I had to go research it in preparation for this. Now, this request actually scared me into buying my own personal subscription to the LLSTC because I'm like, if this happens again, I want to call them. Hopefully, it's before 2 o'clock in the afternoon because we're in Pacific time. I can call them and see what's going on. And they do have a positive law title page there, but does it reference 70 stat 1126? No. So I'm like, oh my goodness. Then I want to say an aha for me, probably every one of you in the room knows this, but I didn't, was this apparently amazing fellow. Does anybody know the name Richard J. McKinney? Yeah, you do in DC. He wrote just about everything on the Law Librarian's webpage that's, finding guides and everything. And he says the U.S. statutes are arranged in chronological order, each set of laws in a congressional session being a statute, and each public or private law being a chapter in a statute. I'm like, that's what the chapter is. Okay, it's the law. And I guess what he's saying is that volume of statutes at large is a statute. Is that what you're hearing, or is that what you know? Are you all following me on this? Okay, because I'm feeling a little better now because I'm like, all this is new to me. So I never did find the answer to this. That's what makes me wonder if I did it wrong because there's no, substantive articles, law reviews. Hint to all of you academics here, if this is real and I got it right, something could be written about. But I never did find anything discussing this phenomenon. And so, and the thing that's really bad about it is if you walk the statutes back to 70A, you don't get a cross-reference back to 70. But if you're lucky enough to do a language search and hit on 70 stat, you will go to 70 stat, and from that citation, you will get the cross-reference to 70A. So then you'll know the text is here and the legislative history is here, but not the other way around. If you're going back, you'll never figure that out. That's why my colleague said, there's no history. Are you all following me? Okay. So, wait, I want to go back to that. How can it go up? Okay. So I did write the Office of Federal Register, like the attorney said, and I didn't hear back from them. I'd be surprised if I do. Now, the other thing, this is all preparing for this talk. The other thing I did is Westlaw and Lexis, and I ran it through their AI products, CoCounsel and Protege. And oh boy, did they hallucinate. I have never run into hallucinations in these products. I don't use them a lot. I use them once in a while for rather simple questions. And I could not, they were saying things that were obviously wrong. I probably should have took some screenshots of it for you. It was unbelievable. So I'm like, that's not working. So I said, well, let me just go to my AI tool that I like. It's Perplexity. And I started talking to it, and it was pulling what it found, and I didn't have time to go through all of the documents that it pulled to verify them. So I'm not speaking authoritatively here. But what I believe Perplexity found, and it sounds plausible to me, is that Title 10's cross-reference citation is a one-time anomaly. That no other titles of the U.S. Code are published as positive law this way. And I have not found an authoritative site. It may be in the Perplexity results that I have, but I haven't had a chance to go and look and see. I really researched around and I didn't find anything on my own. Maybe I missed it. So I thought this is really weird. Have any of you all run into this yet? Wow. All right. Um, now, going back to this danger of a rebellion, what happened? Why did this language, danger of, or danger of a rebellion, appear in 1956? We don't know. And I never found anything talking about that either. Now the courts have spoken on this recently, most of them saying, yeah, there's nothing there. And but I was like, I still want to know. So then Perplexity didn't help me much. So I went to another friend I have called Google Gemini, sometimes that I use. And I just started talking to Gemini about it. And what I came away with was a plausible sounding explanation that I would like to yet verify, but I'm not an academic and I don't have time to do this. I'm doing my branch stuff. Um, Scholars have noted that the Office of Law Revision Counsel's attempts to make language clearer with supposedly non-substantive revisions can lead to murky code outcomes. This is something I'm sure you academics and many of you are aware of, and you've encountered this in all types of revising in the codes, right? Sometimes unintentionally changing the statutory meaning. So the 1903 Dick Act versus the language. It was, you remember the paragraph back in 1903 versus the three in 1956. What I learned is that the revision council, the revision committee, because this was before the OLRC, it was a committee of the Judiciary Committee back then. And I said like it was the 10, I think it was 52 lawyers, 10 years, this kind of thing. They were thinking they were making it simple by putting these paragraphs in there, 1, 2, 3. But when they said or danger of a rebellion, it looks like they changed the meaning of the statute. And this is very relevant today, isn't it? Oregon's Judge Immigrant, there was that separate case, Oregon v. Trump, where you saw our friend the frog, and it came through the Court of Appeals. This was shortly after the Newsom litigation. Judge Immigrant of Oregon, she wrote a really amazing big opinion, and it was good because she was a Trump appointee. And she basically said, this is untethered from reality, what's happening out there and what you're saying. But she cited the statutory ambiguity created by the 1956 recodification, in her opinion. And Gemini also finally got to this observation, which I would like to, validate if it's true. But it sounds plausible, is that paragraph 2 with the rebellion provision expanded the presidential power because what happened was in the Ninth Circuit 3-panel opinion that my judge was on, that I was doing this research for, they ended up saying, no, give the president a little bit of latitude. You can have the National Guard in a state, but right now we don't want you to deploy them to Oregon. So it kind of gave him the authority to put the National Guard in the state over the governor. Paragraph 2 did. But when the Oregon case came through, no, I'm sorry, it's the Illinois case. Paragraph 3 about the regular forces, you may remember that went up to the Supreme Court, and the Supreme Court said, no, you can't do that. So in this instance, the revision reduced his power. So you have here in real time a situation where what the OLRC did in 1956 or their predecessor and what they're doing can have such a big effect on what we're seeing in the world. And you don't think about that. I thought that was really interesting. If Gemini is right, it seems plausible. So post-mortem of all this, live and learn, right? Maybe you know this and you've always known this, but I wish that I knew this. A statutes at large citation does not equal a law. Like I typically say, oh, the law is there. That's a law. But it's not a law because here we have evidence that in the statutes at large, 70 Stat 1126, that's not a law. It's a cross-reference to a law. It's merely where a law is likely, the text of the law is likely printed, but it could be something else. So it's a stand-in for the law. And maybe those of you who've gone to law school, that's very, very clear to you, but it was not to me. I always talk about the statutes as though they were a law, that law over there. But there are instances where it's not a law. I wonder if there are other places where maybe there's just a table there instead of a law. I don't know. And for me, I found that if I had had the time, using the print volumes is worth the travel to the office. A couple of days ago, I went up to the US Code and I walked it all the way back to 1932. It took me more than an hour to do, and I had like probably 15 or 20 books across the table. I'm not a digital native, and I can't do that in Heinlein. Maybe you all can, maybe you younger people can, but for me, I just can't do it. So taking the time, if I'd had 4 days or so to actually drive into the office and go, get the print volumes, I think would have been helpful. But it didn't uncover the legislative history when you do it that way. In this particular case, it didn't. So you need the online search too of the language, and maybe that's your 1, 2, 3 is walk them back and then go to every database you have and put the language in, and then you've covered all the bases. Well, this is new to me. Now I know. And I want to say that in preparing for this, I went ahead to the Law Library of Congress's Legal Research Institute. They have some webinars there that are basic, and most of it I knew what it was, but there are some little tidbits in there that I picked up that it's just like math. If you have everything, then you can be much stronger when you go to the next level. And I think it's worth your time unless you possibly work with this all the time in your job. So I want to recommend that. And I have some parting thoughts here. By the time a request gets to you, it's not easy stuff. Okay?
That's a good insight.
Yeah. Give yourself some time if you can. Now, I'm blaming Washington on this because the courts are going crazy. We're not sitting there saying, oh, the law clerk, I'm going to wait till the last minute and call a librarian. No, it's like they're coming at us from every side. I want it now. I'm not waiting for the case to proceed through the court. That's why we don't have time. So sometimes you can't not have time. But in every case, you can give yourself some grace, no matter what. And that's what made me willing to come here and talk about this thing, because I know I'm not an expert. I know a lot of the terms, I know about legislative history, but I'm not very experienced with tracing them back. And take time to learn if you can, which we're doing today. Now, does anybody have any questions, comments, or am I wrong? What is going on? Or you want to just run out of here?
Do you have one question in the chat? So was the original language altered during the recodification, or is it just the way they organize things? I'm not sure I understand that.
Well, that's what is it, the $64,000 question? Because I never got any notes anywhere on that. Now, I did talk to this. Good news is when I was on the plane coming here yesterday, this lady at the OLRC, she's amazing. She's the one who said, I don't care about the statutes at large, but she was she's concerned about tracing these back and how it's put together in her code. And I wrote her this long email yesterday or the day before saying, look, we have this situation where we have these two sources of belonging to this, but that you don't have a cross-reference to it. Can you please put it in the editor's notes if there's any way? And she called me when I was on the plane. She said, you got to call me before 3 p.m. Eastern time. Well, that ruled that out. So I texted her and I said, look, can I talk to you next week? And she said, yes. So who knows? Maybe we'll get this cross-reference in there. Anything else?
We do have a comment from
Yes.
Julianne that I just answered a legislative history question yesterday about Title 31, which is a positive law title.
Mhm.
And I probably could have cut the time it took me in half if I had heard this presentation.
Wow. So I didn't, okay. I didn't know if I was going to be like, oh, gee, we already know this. I feel a little better. Yes.
So I have kind of a similar murky situation in DC. The first official compilation of the DC Code is not until 1901, and it's not annotated. It's not annotated until 1929. And so I'm sometimes asked, what's the legislative history as it was in 1901? And there isn't any, except I found this House report that Judge Cox, who wrote part of the 1901 Code, testified before Congress that he added sections based on his experience. And we don't know what those sections were. So we just all kind of joke now when we can't find it. It must be a Judge Cox edition. But then there's these weird situations. There's just there is no answer and there's no legislative history.
Right.
It just ends up there.
Right. Well, let me get back to so did you all hear that in the chat?
Just repeat kind of.
Okay, I'll repeat that. Laura from DC mentioned an anecdote about some old statutes in the DC where a judge would just kind of write in what he thought as legislative history, essentially. So sometimes there's no answer, is what she was saying. But what was I going to say about this? I can't remember. I had a thought about it. Oh, well, it's gone. That happens when you're 60 plus. Yeah.
The OLRC, are like work papers or reports when this is what we did, we turned this statute, we turned this original thing and now it looks like this. And even just to say, we didn't mean to change anything.
You know, that's a good question, and I've got this dialogue. I will say the website has a lot on it. It has tables and things, but I have not gotten to the point of looking for reports. But one of the things I did ask her in my email are there any reviser's notes that aren't public that maybe we could get to? This would not be legislative history, right? Because it's not reflecting the intent of Congress, but at least what it would tell us, why did it change? You see? Any other comments or questions? Did we do a minute or two early? All right. Thank you.
Let's give Julia a big thank you for that informative session. She had me on the edge of my seat. I was just kind of like, what, how does this end? So thank you for that. We're going to take a 15-minute break, then the keynote will be next. Catering is outside, and they're going to do some swapping of the food. So we'll reconvene at 12 o'clock. Thank you.